Now more on the Supreme Court ruling we told you about earlier about how closely the government can keep track of suspects. As Jeffrey Brown reports, the issue involves location data, typically transmitted by cell phones.
In late 2010, an armed robbery occurred at a Radio Shack in Detroit. Over the next 3 months, 8 more stores in the area were robbed. Data obtained by law enforcement from cell phone companies helped lead to arrests and convictions. Today, the Supreme Court ruled on an appeal of the case. Marcia Coyle of the National Law Journal was there to hear the decision. Welcome back.
Thanks, Jeff.
It's worth adding, though, one of the ironies of this case is that one thing they were stealing were cell phones.
That's correct, it is.
So what kind of data?
Okay, we're talking about site location data. When you use your cell phone for a call, it pings a cell tower, and your cell phone company keeps a record of where those pings landed. Police want the cell site location records because once they know where the cell tower is, they have a sort of reasonable idea of where the cell phone was used. Mm-hmm. And it was that information that led them to Timothy Carpenter, who was convicted in this case.
And then the legal issue becomes whether that's an unreasonable search.
That's right. Did the police need a warrant? They actually had an order under a federal law that makes it easier for them to access certain kinds of information. A warrant is harder to get. And the court today, in a 5-4 decision by the Chief Justice, said the Fourth Amendment requires law enforcement to get a warrant if they want to access those records because you and I have a reasonable expectation of privacy in that information.
He was joined by the 4, what we refer to as the liberal justices, a little bit unusual coalition. What was the argument from the other side?
Justice Kennedy wrote one of the dissents, and he said that he felt that this type of information was no different from the so-called business record and other information that the court back in the 70s actually said that police don't need a warrant for, because if you voluntarily give business records, bank records to a third party, you have no expectation that the information will remain private. It's called the third party doctrine. And the Chief Justice said, wait a minute, these cell site location records are not like those records.
But the Chief Justice also tried to say this was a limited ruling,
yes, he did.
Right? But this is a very fast developing area of law, right? Digital and privacy in the digital age.
Absolutely.
So what are the implications for the rest of us?
Okay. There are some who believe that this sort of designs a path for protection of privacy in emails and text messages. The chief did emphasize the narrowness. I mean, he said, we're talking about historical cell site location data, not data that's collected in real time by the police, and also that there are exceptions to the warrant requirement if evidence is going to be destroyed, somebody's kidnapped, there's a bomb threat. That also limits the ruling, he said. But he very much has an eye on the future. He talked about this digital revolution that we're undergoing, and the dissenters felt that the principles in this decision will open the door to a lot more litigation and actually endanger certain law enforcement investigations.
And very briefly, in this case, the conviction goes back to a lower court?
It does. I mean, basically the court is saying you can't use the evidence because you didn't have a warrant. It'll be up to the lower court to see, as well as the prosecutors, if they want to try this fellow again without that evidence.
All right, Marcia Coyle, as always, thank you.
My pleasure, Jeff.